Welcome to the Kapital podcast, intelligent conversations with Marceline, London, Midlands, North.
Hi Ryan, and thank you for joining me on the show today. I'm really excited to have you on the Urban Capital podcast. It's great to have somebody with your level of expertise on our first show. So I'm really excited.
It's all mine to be here on the debut. Thank you.
I'm kind of doing things around the coronavirus for this first show because it's the topic obviously on everyone's mind. But I wanted to make sure that the discussions that I do have are relevant to the real issues that people are concerned about at the moment. But if you don't mind, would you tell my viewers, listeners, a little bit about yourself and your background in terms of who you are, what you do?
Right. Okay. Well, as you quite rightly say, I specialise in employment law. I do also specialise in other civil matters as well, but primarily I'm known as an employment law barrister.
Yeah.
I started off life as, believe it or not, a quantity surveyor. That was my first profession. And while I was studying for a degree in quantity surveying, I took the law options of contract and tort, etc., and found that my love was more for the law than it was for surveying. So then afterwards, I entered for the bar entry exams, got in, and then sat the bar, passed it, and then got into chambers. I did a master's in law as well, which I believe is not a million miles away from. Well, I use Nottingham Trent life facilities. Yeah, I didn't study there, but they allowed me to use their facilities because I was helping out someone with some legal work up there. And yeah, the facilities must have been very good because I managed to get what's equivalent to a first class in the masters. So I put that down to Trent's library than my ability. And here I am practicing the bar as an employment lawyer. So that's, a quick summary of how I got where I am today.
Oh, okay. I'm sure Nottingham Trent will be very, very shocked to hear that.
A lot.
So in terms of the kind of work that you do then, so
yeah, I mean, I work for both employees and employers. So they'll either come directly to me or via a solicitor. But in this day and age, they normally come directly to me because barristers are obviously, like most people now, or most professionals anyway, the internet and so on, so they can be contactable. So when it comes to an employee, for example, they will contact me and say, look, I believe I've been discriminated against, or I've been unfairly dismissed, and so on and so forth. I will ask for some papers or ring them up and find out for more information and then decide whether or not they have a case based on what they had told me. Because, of course, you're hearing one side of the story, not the other side. And then if I feel they have a case and they want me to represent them, then we take matters further. And it normally depends on what part of this, at what stage they're at that time. Because, for example, sometimes they may have commenced action against their employer or former employer on their own. And what I find there is that no disrespect to most, but they tend not to detail their claim as well as it should be. Or sometimes they issue the claim far too late. And it's something I hope that we could probably come on to later on with regards to timing. Because, it's not unusual that someone will contact me and say, look, I was discriminated against, I believe I was discriminated against a year ago, and therefore can I bring a claim now? And sadly, they can't because they're out of time, way out of time. So both sides and all aspects of employment law will contact me.
what are the most common type of cases that you see this day and age in terms of, what from employee taking as a tribunal?
Yeah, I think it'd be discrimination, and that will be in a pecking order. I would say race and sex discrimination are probably the main top two together. Below that will be probably disability discrimination. You tend not to see sexual orientation that much. Maternity Yeah, you see that as well. And you can see how that will come about, because what will happen is that, normally will happen, is that someone will go on maternity leave, and in that person's absence, the company will somehow restructure to cover that person's work or workload. And they find that, oh, we're doing okay without Sarah being here. And then, so when Sarah now wants to come back, there's sometimes difficulty. I mean, the law does protect the job, but employees don't always know that they're supposed to be protecting the job for the person, and they tend to think, oh, we can save, on an extra salary because we are doing fine without this person. So that tends to be the pecking order. The other thing is unfair dismissal, and I dare say there'll probably be quite a lot of that, sadly, now and after we've come out of this pandemic thing we're in at the moment, where sadly many people would lose their jobs. But I think some people will say they've been unfairly dismissed because why them and not somebody else, for example, or whatever the case might be. That tends to be, and the new one is also whistleblowing. Whistleblowing is quite big as well. Public interest disclosure, where someone alleges that their employer is doing something wrong, and they've been dismissed, or they feel they've suffered some sort of detriment, and they say the employer has dismissed them or subjected them to this detriment because they whistleblew. Had they not had not whistleblown, then the employer would not have treated them that way. They're probably the top three.
Right, this is very interesting. So, just coming back to racial discrimination in a workplace, and I know all discrimination has to be proven, doesn't it, in terms of a series of events or things that you can identify. It seems to be the discrimination that is hardest to prove. Would that be correct?
Yeah, that's fair. Yeah, that is fair. Because if for example, I can compare it to unfair dismissal, or a case where someone's alleging that they've been unfairly dismissed, you tend to have some sort of process, some procedure, there's paperwork. Let's just say, for example, someone was summarily dismissed for allegedly stealing something. You have a trail of what it is. This is why you were dismissed, blah, blah, blah. The person thinks, well, the sanction was too heavy, or it wasn't me and I shouldn't have been dismissed. By its very nature, and the law does recognize this, by its very nature, discrimination is very rarely something that someone stands up and says, yes, you are this, you are that, I'm going to treat you this way, of the difference because of your race. So it has to be examined why someone acted the way they did. And I think the difficulty sometimes also is that the alleged discriminator doesn't really know they're discriminated against. If you're talking about something like an unconscious bias, for example, it's very hard for the person to accept I acted the way I did because, of the person's race. I haven't got a racial bone in my body, blah, blah, blah. But you do have two people who are qualified, who are deemed to be of different races. And you choose one that you believe fits more into the culture of your company than the other one. And what's the difference between the two? Yeah. But also as well is that with race discrimination cases, with most discrimination cases, you've got to have a comparator, because we all have characteristics. We all have a race, if we're talking about the statutory race, as opposed to the human race, which is only one race. But, it's a statutory race of colour and nationality, ethnic background, that kind of thing. So you need to have a comparator to say, I was treated less favourably than somebody else, not of my race, and this is the proof. Now, therein sometimes lies a problem, because it's not always obvious that someone, a colleague of a different race, you've been treated less favourably than a colleague of a different race at work, because you don't always know, and so on and so forth. So it's very difficult, but it is hard to prove, and the law recognises that. And having proven your case, if you can, the law then recognises that you would have suffered some hurt feelings. So you automatically get an award for injury to feelings, as opposed to a case where you've got to prove your losses. The law recognises if you suffered some hurt.
Because that's the thing, isn't it? I think what a lot of people don't realise, when I say a lot of people, if people have never experienced racism, and especially things like racism in the workplace, where, as you said, it's not always overt. It's not somebody in the street calling you names or anything like that. And like you said, that impact that it can have on you as an individual, and your sort of confidence and everything else, it actually can be quite huge, can't it? So it's an important thing to acknowledge if it is happening, or if somebody is experiencing any kind of discrimination.
Yeah, it is. And when one is, I mean, sometimes someone doesn't want to act in a particular way to be labelled. They've got a chip on their shoulder, and we all know about the last thing you really want to have, that label walking around on your head. But it has that psychological impact. It's not just simply a case of what might be a minor trivial thing to one person, a one-off event. It has its continuing consequences. For example, on one's confidence, on one's inability to secure another employment. They're more than confident. I mean, they're more than qualified to do so. But of course, they often reflect to the treatment they've had, and they said, "Why me?" And I dare say sometimes, and I've had that, where someone clearly believes they've been discriminated against, but somehow they feel that they've contributed to that. They treated me the way they did because of my race, because of how I acted. I mean, it's really, really complex. It's really complex.
I think I kind of understand that, because I've worked in environments, in terms of what I do. When I was employed, I worked in environments that were typically, and admitted by everyone, were typically run by white middle-class men, who, I don't think there were racial issues necessarily, but sometimes they didn't get anyone on the office floor. But yeah, it's just that thing of when certain things happen and you do suspect it might be racial. And I'm going to give an example where I've been in an office and something's happened that's upset me, or somebody might have said or done something which I find offensive, and I'll take a minute, or I might have a word with whoever I need to have a word with, and say, and then you get things like, don't get so angry, and then words like, don't so aggressive, and so you do start almost dumbing yourself down so that you're not interpreted that way. When another colleague of a different race may be in a similar situation, burst into tears, and everyone's rallying around and saying, "Oh, don't worry about it, everything will be fine." And you kind of think, so when I'm upset, I'm angry and aggressive.
No, and it's a very good point. It's a very, very good point, because what some people may do, the language they use is associated with the sort of whatever the characteristic, not the characteristic, like a woman, for example. Someone might be, "Oh, she's acting so much like a man because she's blah blah blah." Yeah. Whereas man is just doing his job and being, God, he's really assertive, isn't he? Really, really assertive. Woman's acting exactly the same way, using the same language, and we know, I just said what's been said there. And also, I'm gonna say subconscious, I suppose more unconscious, really, where someone is using the language like you've just explained just now. Aggressive. If you're talking about a black person, I'm not saying what everyone says that, but I'm just saying, we grew up in that sort of thing where it's the aggressive, angry black male, whereas somebody else may not be described in such terms. What immediately springs to mind are not necessarily those words, and so on. So yeah, no, there is that way, but unconscious bias is very difficult to tackle. Very, very difficult, because it's about conditioning and about various things that you don't even know you're doing it yourself. So you need to have checks and balances to say, right, I've selected this candidate over this candidate. Have I done the right thing? Is it based purely on experience and qualifications and suitability for the job, etc.? There's a lot there. A lot. Very complex.
And there's that issue as well, isn't there? Of, I know someone that recently won a case against a very big institution, and it was actually, she was called certain names, and certain references were made to her being a slave, and all sorts of things. And it went on over a period of time. And I remember after her case, she contacted me and we were talking, and she was saying the hardest thing in the court was that she felt she had sort of, if you like, white legal teams, white judge making the decision, etc. And she felt as though who in the room she was saying, I'm explaining to them the races, and they're telling me, no, it's not, it was a joke.
Yeah.
So that I'm in a courtroom.
Yeah, the old question about what's a joke and what's banter, at work, and it's they're more of a mix in the employment tribunals. If I can still use the word of racial mix, it's more than well. Obviously, when I started doing employment tribunal, over a couple of decades ago now, there aren't enough, but you can't blame the system for that. There have to be more people coming forward to put themselves in that position. You have in a tribunal, in the case of discrimination, you will have 3 members sitting on the bench. The person in the middle is a judge. It'd be a solicitor or a barrister. When the wing members, they're ordinary members of the public as well. I'll put it another way, they're not lawyers. Yeah. So you can apply to become a tribunal member. So if you go to the employment tribunals, I suppose we can't take it that because there is a woman sitting on the bench and a woman is alleging sex discrimination, that the decision will necessarily go in favour of the claimant. In the same way as if it's religious or race or what have you. But what I think it does, it may just give the claimant some comfort that if the claimant is unsuccessful, they may just think, well, you know what, I'm not walking away from, if I'm a woman, losing my case with 3 males sitting on the bench who just didn't get it. I think that woman must have got it, and she just happened to, decide against me. Because unfortunately with these cases, there are no draws. It's not like a football match. There cannot be a draw. Someone has to win and someone has to lose. But I just think it will just give that comfort, knowing, well, there was someone there. I think the person would have got it, even if the other 2 didn't, and they decided against me. I'm not happy with the decision, but I accept it. And I think it just gives that comfort. But people have to come forward. It's not if they haven't got enough of a mix on the bench. Come forward and so on.
Yeah, I think that's a great point as well, because I think a lot of us, I'm actually talking about this with some of the young people that the youth shows, about the type of careers that we choose and how easy it can be to kind of limit ourselves. And then so that's not going into law or not going into, pushing to become that judge, and then going into those situations and other similar situations, saying there's not enough people like me. But like you said, if we don't go in, we're not going to see them.
Yeah, and that's a valid point. Many years ago, I was asked to give a talk to Hammersmith and Fulham something council somewhere, and I said at that time, when I became a quantity surveyor, I don't think I met one black quantity surveyor. You've got to, and I was in a professional practice, and I was going on site, and invariably I was probably the only black person there. And then when I wanted to go to the bar, interestingly, the people that were the biggest hurdle in saying don't do it were actually black people.
Really?
You don't see a black architect. You don't see black barristers. And so to some degree, that was, it didn't obviously discourage me because I went forward. But the point is that some people who make the remarks were saying, well, there aren't enough of a certain race or what have you in a profession. Well, what about it? You've got to go in. Not going into it is not going to solve the problem. If you see it as a problem, you've got to go. If there's not enough, then, if you want to go into that thing, then apply and begin your journey. But I have to say that was, I wouldn't say the biggest hurdle, but it was, one's conscious of that time. There weren't many. And actually what I did, I as part of my master's, because I did a research on, I think the effects on ethnic minorities in the criminal justice system or something as part of that. Something like that is my master's, my thesis. And so I had to go through the whole system of from the solicitors, barristers, and so on. And I saw many stats that says this is the number, the percentage in the population of this particular, like 5% Black and Asian and Indian and so on and so forth. And this is the percentage in the profession. Now, those figures were there. To me, that wasn't really what I was looking for. What I need to find out is how many are attempting to enter the profession and how many then didn't make it. And let's find out why they didn't make it. Not simply, oh, there's 5% in the country, and therefore there should be 5% barristers. That's not the way it works. That's not the way it works. Let's find out how many applied, and how many didn't get in, and why didn't they get in. That's a true. That to me is a true picture, a representation of what's happening out there. So go for it, is what I say. You know, that's what you need to do. You need to, if you want to do it, it should not be a barrier. There aren't enough of certain people doing it. Should be, well, I want to do it, so I'll go for it. Simple as that.
Yeah, I absolutely 100% agree. And like I said, in a lot of the roles that I've often been one of very few females, usually the only Black person, and I just don't let that stop me or put me off. I just keep going. Like you say, if you're working with good people anyway, it doesn't really, it's kind of, it's where do I want to go and what do I want to be and what kind of example do I want to set to my children, for example. So yeah, I think that's a great point.
Yeah.
So moving forward a little bit then, so coming on to the whole coronavirus situation that we find ourselves in, which is affecting everybody, isn't it, in different ways. It's affecting us all in the same way in terms of the isolation, change to our lives. But people that are employed and on lots of different levels, I'm thinking here now, if I even start with thinking about small businesses, the impact that it's having on them and the further impact that has on them in terms of their employees, how they're going to come up with no matter what level you look at this on, people are worried about their jobs, aren't they? Employment. It's a very unusual time in terms of the economy and employment. So talk to us in general. I know you'd put on social media earlier, which was giving people a general overview of the laws that have not changed whilst we're in lockdown. So start with that. Tell us what people should be aware of in terms of what they can be sure is going to be still in place for them in terms of protections in their jobs.
Right. Yeah. Have we got a few days?
UK youth, representing a diverse young Britain. Follow the socials, #UKpodcast.
So that's all right. That's sensitive and everything's fine. But a summary.
No. It is a great question because it's one that's been keeping a lot of HR, human resources people busy for the few weeks. Now, the first thing is what I think has caused some confusion to some people is the use of the word furlough. Furlough's been a word. It's an ordinary English word, but it's not a word that we use or we associate with employment in this country. They do it in the US, I understand. So when the government made its announcement, effectively, it was obviously it was to prevent people being made redundant. That's what they say, to keep people employed. And that obviously helps the economy later on and so on. So because of the impact on businesses, some businesses are going to fold. I mean, some businesses will be struggling anyway, because we know it's a new business. We know that in the first 3 years, most businesses do not succeed, period. So rather than make your certain employees redundant because of the consequences of the government's decisions that they can't open businesses, certain businesses can't open, etc., the government said, if you can keep those people employed, you can apply for 80% of their salary up to a maximum of £2,500, provided you keep employed. Now, it's called a job retention scheme. It's a little bit confusing because what has happened almost every week, we're getting some updates, and it's not solely about keeping people from being redundant. For example, if someone stays at home to look after their children or someone who's vulnerable to COVID-19, that person can also be furloughed. There's no question that person will lose their job, will be furloughed. So the title in itself is misleading, but it had good intentions, and I do believe good intentions generally. The problem is, I think the consequence of this, a lot of things are going to happen. What was normal before will not be the same when we come out of this, for a number of reasons in my view. Firstly, if the government were to announce on, say, Sunday, it's all over. On Monday, businesses do not pick up from where they were a couple of months before. It's going to take some time. So those people who are furloughed, the question is, will they still be employed by the companies? Sadly, I don't believe 100% will be, because the company cannot afford it, because they've not had any income coming in. Remember, the government's covering 80% of their salaries, but that still wouldn't necessarily be enough for a company to continue trading in the same form. It might take them a year before they get into the position they were a couple of months before.
Well, so I guess still having to pay that 20%, and as you said, there's no income coming in, but there's potentially still money going out of the business, isn't there?
Yeah, that's. I mean, what the government says in their guidance, and bear in mind the HMRC is just a guidance. It does say it's up to the employer if they pay the 20%. But you do need to speak to the employee and see if the employee wants to be furloughed in the first place. They may not want to be. And I know there's been much discussion that, well, of course you'd want to be furloughed because otherwise you may be unemployed. And yeah, generally speaking, that's quite right. But the other side of that is that if you're furloughed, it's an alternative to being made redundant. So in your mind, psychologically, you're thinking, well, why choose me? Why not choose the next person? And that's where there could be elements, I think, of claims under the Equality Act coming. You know, some might say, well, most women have been furloughed as opposed to these men in the office. Is it because they think these men can keep the ship afloat while they furlough? You know, there may be things like that. I dare say that's the end of the story. And the HMRC does say the Equality Act still applies. In fact, all the laws still apply. So another thing that was going to happen, I think, is that companies who may have thought before that we can have some people working from home but not sure how it would work, will now be able to determine, and this is not a furlough point. With a furlough point, you're not allowed to work. You're working from home. But just a side to that, companies will probably see, oh, right, we can function reasonably well while some people are working from home. So therefore, we don't need these 5,000 square meters of office space. We can have these people working from home and so on and so forth. So I think that's also going to be a change I think I can see companies downsizing their head office and space while people work from home. There will also be some employees say, I'd rather work from home. There's also, it's not necessarily, not everyone wants to work from home, but there might be some saying to work from home. There might be some companies that say, actually, no, we want you to come into the office. There could be some conflict there because the people say, well, I work perfectly well from home, and now you're saying I can't. There'll be the other way round as well, where, you know, the company says work from home and people say, I don't want to work from home. I want to work in the office. I don't really stop. I mean, believe me, where you're interviewing me now, I've been stuck in this place for so long.
I know. It's like your living room becomes your prison, doesn't it?
Absolutely. I never thought I would say I'd miss travelling to these courts all around the country that I do. I want to go out back in some courts. I won't mention the names, but I miss you.
Well, at least your job can't be done from home, I'm sure. Can it? Not fully.
There's the paperwork, but no, we haven't quite got to the trials yet. I sort of wonder how my clients will give me instructions without the opponent hearing when my client is like in Southampton, I'm where I am, and want to tell me something that everyone else can hear it. Yeah. So we have But technology will help us in this, because I think, to that point, technology has forced some people to see, actually, you know what? Do I need to meet counsel in chambers all the time? Why can't we just go on Zoom, or as I've recently loaded onto my computer, and just have a conversation with counsel there? In that way, I have to pay for counsel to travel, to do this, that, and the other, and we can have a discussion that way. So it's working practices are going to change. But, coming back to your initial question, I did write that in my view, it's business as usual. I think it is business as usual, in the sense that employers mustn't think this is an opportunity to maybe get rid of someone, maybe to say, whatever it might be, you still got to act fairly. And we use the term saying within the band of reasonable responses. So in other words, you've got to be reasonable in every decision you take in how you treat an employee, whether you're furloughing them or not. So things do not change in that respect. And
another question I have for you around cases, you touched on it earlier, that if somebody was perhaps in a situation or experiencing a situation, so whether it's discrimination, whether it's, unfair dismissal, etc., and we're considering taking a case, but that didn't happen before this lockdown. So let's say they've been in lockdown for 3 weeks. Should they wait until they go back to work?
Absolutely not. No,
is there a time limit?
Yes, indeed. Yeah, and that's why I say, although we're going through what we're going through, the laws, the timings, and everything still apply. So in other words, if you were dismissed on the 1st of January, you have to bring your claim or notify ACAS within 3 months and 1 day of that dismissal. If you don't do that, you're out of time. And it's the same thing with if you're bringing a case of discrimination. You have to bring within 3 months, less 1 day, of the alleged act of discrimination. You don't wait till you go back to work, because going to work has nothing to do with the tribunal system. The tribunal system is still in place. It may not be functioning 100%, but it still has its time limits and things you have to work to. Now, what I say to people often, although you have the 3 months within which to bring your claim, don't wait till the last day. Get it done in time. If you feel you've been discriminated against, then and you want to bring a claim, then do so in good time. If you've been dismissed, you have to know you've been dismissed. So why wait 3 months to bring a claim, or after that, for that matter, if you think your dismissal was unfair? So yes, and the tribunals are very strict on those times as well. They will extend them sometimes, if they think it's just and equitable to do so, but the chances are your claim will not be extended. And if you're 1 minute late in lodging your claim, it's the same as being a few weeks late. The tribunal is very, very strict. In fact, I've got one case I'm opposing at the moment where the opponent is out of time by 4 hours. So in other words, lodged a claim, the appeal, on the same day, so it should have been at 4 o'clock, and lodged it at 8:45. And the appeal court said it's out of time by 4 hours. So it's strict, very, very strict. Don't leave it to the last minute. So you must bring your complaint in time. And it's also important as well to look at what some people call a continuing act. So what that means is, if you've got persistent, you believe you're subjected to consistent acts of discrimination, that's called a continuing act. So it started on the 1st of January. So-and-so, every day I come into work, so-and-so is only sexist remarks and this, that, the other. And then you bring the claim in June. You could say that's one long act that the clock starts from the end of June. But sometimes what's very, very complex is that there's one decision that has continuing consequences. And people tend to think that's one continuing act. It's not. So let me give you an example. We're talking about furlough and so on. Now, if a decision to furlough someone was, say, arguably on the 1st of March, and you're still furloughed till, say, I don't know, the end of May, the clock, in my view, doesn't run from the end of May. It runs from when the decision was taken. That's what you're arguing about. You're saying the decision to furlough me was based on some unlawful means. I'm a woman. I work I'm a woman. There's Jack. I was here longer than Jack. In fact, I can do my job better than Jack. But you furlough me because maybe that's easy. You think, oh, she want to be at home with the kids, doesn't she? So I'll let Jack stay here. But the decision to furlough you was taken before. The consequences might have continued for months. So it's keep an eye on those sort of things as well. They can be very, very tricky. Very tricky.
Yeah. And I suppose one of the key things as well is that if you are not sure about whether you've got a case, or if it's something that, you've experienced something that you're not, you can actually contact.
Yeah, I mean, there are, you can, there are some people, there's some organizations will give you like 30 minutes free. There's many people, I speak for myself. Let's just speak for myself. If someone emails me, of course I work for a fee, but I can't resist. I'm not encouraging people just send me loads of like free work, pro bono. But, if someone just says, look, generally this, that, and the other, the chances I would respond to it in general terms, and so on. But if you believe that you have an action, then raise it, because the tribunal will not necessarily assist you if you thought you had an action, did nothing about it, and then one day you're having a conversation with a friend and you think, oh, you know what? Yeah, I thought that. Well, I'll raise it now, a year later, because the tribunal also have to be fair. And they have to see that if you're raising an allegation a year later or 2 years later, then the opponent has to have the right to defend it. Because believe me, it's very rare. I don't think I've ever, in all my years, had a case where someone has alleged discrimination and the opponent accepts they're discriminated. So it's going to be defended.
That's an interesting point, actually.
Yeah.
Well,
you see, the thing is, there is a hierarchy, irrespective of what criticisms people may label at some employers or some managers or what have you. There is still that stigma, I think, attached to certain things. And the reason, earlier on when we had our discussion, I mentioned about a hierarchy in discrimination, like race and sex are up there. Age discrimination tends to be lower down, because companies do not want to be labelled with something like that. I'm not saying they've gone out to do it, but they definitely don't want to be labelled as being a company that racially discriminates or discriminates against women on the grounds of their sex. Could be a man as well. So an unfair dismissal claim, if a decision goes against an employer that they unfair dismiss an employee, it's not great, but it doesn't have the same stigma attached to it than to be an employer who's deemed to have been discriminated against an employee on the grounds of race and so on. So that's why those things are viewed differently in my view, because an unfair dismissal claim might just be the procedure was wrong. You should have interviewed 2 people and you didn't interview 2 people. Had you interviewed those 2 people, the person might not have been dismissed. So, and that happens, it's almost like a human error to some degree. Whereas, discrimination is more than that. It's more than that.
So somebody that might be at home now, or might have lost their job because of this situation, or is furloughed or anything like that, and they're sat at home thinking, okay, I want to put in a case against my employer. Ordinarily, there would be a process in place, or that the employer should have in place to escalate a complaint. So if the employer is not open at the moment and that person is sat at home, and with the additional stresses that we've got with the whole pandemic, not being able to go out, they may be thinking, I may not have thought about that case. Do you get what I mean? At the forefront of their mind.
Yeah, and I think that's a valid question, because I think a lot of people will be facing that. I mean, the example will be if the employer has taken the decision, for example, to dismiss an employee, because you can be furloughed and still be dismissed. So you're being furloughed, and after a few weeks, you realise we're going to dismiss this person anyway, and that means the furloughing then comes to an end. And let's just say, for example, as you say, the employee is closed. There's no point just sitting there waiting for a few months when the employer's going to be up and running, functioning. You have a right to appeal. So you have a right, and your contractual right, the ACAS Code of Conduct, is usually within 5 working days. Also, you have a right to appeal. Carry on as normal. If the employer is not in a position to deal with your appeal, that is the employer's problem. It's not your problem. Don't just sit there and wait and, your 3 months is gone. You say, well, they weren't back, I didn't appeal. Appeal within the contractual stipulated time, the 5 working days. The employer's going to deal with it. The employer may have a legitimate excuse. We know there are difficulties out there in saying, look, we couldn't get someone to chair your meeting. We couldn't interview certain people. We can still function. We can still actually interview someone because you and I have no chat and they can no doubt do the same sort of things. So these things can happen. If later on nothing has happened, concrete's happened, still keep your eye on that clock. Because if this happened, I know it wouldn't have happened in the 1st of January because all this furlough talk didn't come till later on. But let's just say it did. Is it dismissed on the 1st of January? Make sure you bring your claim by the 31st of March. The 3 months less 1 day. Not the 1st of April, you're out of time. Do so. Just act as normal. Otherwise, you'll be out of time. Because there's no guarantee the Employment Tribunal is going to extend time simply because every whatever time you sat and watched the news on COVID. That's not them.
So another question. So just to clarify your answer on that, then you weren't clear. So if I'm at home and I don't know, I've been dismissed yesterday, and I think I've got a case, I should follow the employer's process as the office.
Yes.
And if that employer didn't come back to me, does that still class as me officially logging that complaint at that time?
Yes, absolutely. Because you also will have, sadly, in this day and age, that some employees don't have a written disciplinary or whatever procedure we're talking about here. They may not even have that. But you've got to be careful. You were dismissed on this particular day. So you act as normal. Remember, it's really the employer's problem if they can't get their act together in getting someone to deal with your appeal. They don't deal with it. You just lodge your claim. The tribunal will see, you're acting in your best interest. And you carry on as normal. Later on, it might be that things are stayed. It might be that the employer applies to have proceedings stayed because they couldn't physically really have conducted the appeal. That's fine. Let them do that. But don't jeopardize your own case by waiting. Put it this way, if they got the resources to dismiss you, they've got the resources to do with your appeal.
Yeah, true. Actually, great point. So, just before I let you go then, this has been a brilliant conversation. I've learned loads myself as well. We touched on it earlier about, so I suppose younger people not limiting themselves in terms of career. But in terms of the law, you talked about when you were doing season, looking at the numbers in different industries, etc. In the world of law, in your do you think that's changed? Has it got better? And what would you say in a nutshell to a young person that might be into the legal?
Right. Well, the law is very competitive. At the bar anyway, the private bar, it's very, very competitive. But I mentor loads and loads of people. That's something that I would not turn away. So if somebody contacted me and say, look, I want to get into this profession. Can you mentor me? The answer is yes. I'm telling you that now. Definitely. And the reason for that as well is that, one, you want to encourage people to enter this profession, and it's a very good, challenging profession. When you take up a case, you're dealing with your client's case, you're doing the facts of your client's case, you're trying to put it in the best light you can, you're capable of doing. You've got an opponent who's doing the complete opposite, in putting its client's case forward. And then you have the intellectual battle between you and your opponent, and then trying to persuade those 3 people or 1 person in front of you, the judge or the judges, that why your client should succeed in their case. But it's also as well that I said, when someone said it's very hard to do something, I'm very disappointed if I hear after that, it's very hard, I wouldn't do it if I were you. I wouldn't have done it again. Because the way I see it, there's a sense of arrogance in there. If I have done it, then so can you. If you say, I wouldn't do it, it's almost like saying, I've done it because I'm capable of doing it. But I wouldn't go there. I mean, that's just the highest order. So try, if you don't succeed, but at least you tried. At least you tried. I was going to cite some poetry, but I'll probably get completely wrong and embarrass myself. So it's better to have loved and lost than never to have loved at all. So, right, I'm not saying that's Tennyson, I think, but I'm saying it's better to have tried and failed than never to have tried at all. I probably should have said that more, because some poets going to say, you know, Tennyson didn't say it as badly as that, but there you are. But no, definitely do it. Definitely do it. Go for it. It's a challenging, it's rewarding at all levels, and it empowers you. Because even if you don't enter the profession, knowing the law, because the law globally, contract law, knowing your rights, it gives you that confidence to know, you know what, I know my right. I know that when I go into a shop and, you know, you display something that says it's £5, and if I go there and say that you've said it's £5, I want to pay £5, and you say, actually, it's the wrong price, it should be £50. If you're arguing, you've got to sell it to me at £5. If actually, in law, you've actually got it wrong, because they don't have to sell it to you at all. You know, so but you know, these are various things. You're just empowered to know what your rights are. So I think it does strengthen you. It does. Yeah. If I didn't become a lawyer, and bear in mind, you know, I've done other things as well, I would not say my legal education was wasted by any shape or form. It's been, you know, very helpful indeed. So enter the profession if you want to.
Yeah, I do. As well.
Yeah, you're number one on the list. I've just written you down.
Right, thank you so much.
Well, my pleasure.
Yeah, you've been absolutely fascinating. And I know that our listeners and viewers are going to thoroughly, you know, enjoy listening to you. I know we talked about some serious things, but I'm sure they're going to feel empowered by having extra information as well.
Thank you very much for the invitation. I know I'm here. No matter what happens by those who follow me, I know I was on the first one. So that's very special. Thank you.
Keep reading the magazine.
Yeah, definitely. I shall indeed. And you enjoy the rest of your Easter. Take care.
Take care, Ryan. Bye.
Urban Capital. Lifestyle, society, entertainment. News, politics, economics. Urban Capital. London, Midlands, North.